And that's what's led to the 7 March 2017 document, is that right?
Yes, because now it's specifically dealing with child abuse matters.
Yes. So let's go to that then. At tab 11, there's a letter from the solicitors. Perhaps there isn't. In any event, that's the first document at tab 11 is a solicitor's letter dated 8 March 2017, which in the main paragraph says that we've been working on developing a policy statement of Jehovah's Witnesses in Australia in relation to child protection. As the final draft has only just been completed for distribution to congregations, we are pleased to provide a copy of the child safeguarding policy of Jehovah's Witnesses in Australia. And then that's the document that follows. Now, firstly, in relation to this document, has it yet been published or made available to congregants generally in Australia?
No, it's dated for release in March. It had been planned some time with the wanting to get it to the Royal Commission before this. I feel this is the final version. It has been approved now by the branch committee. It is an Australia document. It's not a worldwide document, so we've been able to give approval for that now. So we anticipate in the next week or so it will now be made available to congregations throughout Australia.
And when you say you got approval for it, that's from the World Headquarters or the governing body, is that right?
Yeah, a draft was obviously sent to the Coordinators Committee who look after legal matters for the worldwide field. But the Australia document here gained final approval by the branch committee for release.
When was it adopted by the branch committee?
Just this last week we've given the final version, the one that you have here.
You mean this week or do you mean last week?
No, this week we finalised the final edits on it, just a few minor edits.
Was there a meeting of the branch committee this week that approved and adopted this version?
I think the meeting was held previously. We would have just circulated it for final review, but it's only had a couple of minor edits to make on it.
And when did work on this document commence?
Well, I'm not sure on that. That's happened since my transfer to Papua New Guinea, but I think Mr. Spinks has been involved in that and he could give you a much better answer to the question.
So, immediately following the public hearing in case study 29, we went away with a clear picture, as did the representatives from headquarters here, that we needed to make some adjustments with documentation, which we incrementally did. So there's been a lot of discussion about this. It's actually based on a policy that was under development and issued for the UK, but obviously there are some different implications there. So it's been a drawn-out process, and towards the end we wanted to have it available for the Royal Commission. When our hearing date got brought forward, we have had to move quickly. We didn't send it to the congregations this week for the obvious reason that if there's a suggestion or discussion, we just wanted to reserve the right to make any minor adjustments before it's distributed. But it's taken some time, but we've actually brought it forward a little bit so we could present it to the Royal Commission.
And how long ago, Mr. Spinks, was it in a form similar to the one that we see now? In other words, leaving minor changes aside.
I'm not certain with regard to the UK, but I would think over the last 3 or 4 months there's been discussion and video conferences and that to get it into the shape that it's in. We wanted some specific inclusions, which we're glad glad have been included. We've referred to it as a living document that we want to make whatever adjustments need to be made to it, further adjustments if necessary, so that it's applicable for Australia.
Back to you, Mr. O'Brien. Is there any plan, to your knowledge, to revise, organise to do Jehovah's will, at least in relation to policies and procedures responding to child sexual abuse?
I'm unaware of any plans in that line.
Now, in relation to S66, so that's the guideline to service desks, I'd like to refer you to tab 21. Now, this, if I understand how to read it correctly, in the starting to read it 1/3 of the way down the page where the World Headquarters heading appears, there's a letter from World Headquarters to branch committees of all branches. Is that right?
That's correct.
And then above that, there are two other entries. Can you just explain what those are and the time sequence in which they occurred?
Yes, that's a standard way we respond. So the initial letter that you referred to there from World Headquarters to all branches is the first mailing. Then if there's a brief response, not requiring a second letter as a response, then the letter note, we refer to that as above, is provided. And then if there's another brief response, which is the top one, is another response to that.
Right, so one reads these in reverse order like email chains, is that right?
Yeah, that's correct.
And now in the letter itself, and the second bullet point, you'll see it says that the letter of 1 August 2016, so that's the document we looked at earlier at tab 6, or 7 rather, will replace the letter dated October 1, 2012 to all bodies of elders. So I take it that's right, it replaces that earlier letter.
That's correct, yeah.
So as of the date of the 1 August 2016 letter, the 1 October 2012 letter no longer applies.
That's true.
Right. And in the main paragraph in that letter, I don't intend reading it, but you'll see that much emphasis is placed on the confidentiality of the S66 document, and it says as to who specifically it can be given to, including that it's not to be given to service desk secretaries. Now, can you just explain what is I know this instruction didn't come from you, it came from World Headquarters, but I'm hoping you can assist us. What's the secrecy or confidentiality concern with regard to this guide to service desks?
Once again, I could defer to Mr. Spinks, who'll give you a more accurate answer than what I'd be able to.
He works in the service desk. Yes, Mr. Spinks.
Again, I probably can't answer for the reason that it was written there, but I guess those of us on service desks have been given a heavy responsibility, as we see it, to ensure that we meld together the August 1 letter and the service desk guidelines. It's a responsibility we take very seriously in giving advice out. So my reading of it was simply that it's the responsibility of the service desk to make application of it and has ownership of the document. Beyond that, I couldn't comment.
We appreciate that someone from outside the organisation might struggle to understand why there should be such secrecy with regard to something which is a procedural document as to how matters should be handled procedurally. Do you see that?
I recognise that, and this came up in the earlier public hearing, that there's no doubt that some of our correspondence, it's well understood by the audience it's intended for, but read from a critical perspective, and we appreciate that, that it could be seen that way. our understanding of it, or our application of it, is the elders have a letter that applies to their function and role. The service desks have guidelines that are specific to their function and role, and there's some reasonable amount of discretion required in the application of that on a case-by-case basis. But I take your point.
See, it might leave someone with the impression that there's really a dual practice here, that congregants are being kept from information which, with regard to processes that govern their lives or govern issues that arise in their lives. Do you see that?
I understand that criticism that has been made. From our perspective, it's audience specific. The instructions are there for a service desk to make application of it. Again, I take your point.
Now, Mr. Spinks, while we're with you, you may wish to answer this question, although, Mr. O'Brien, if you have something you wish to say about it, by all means, do so. Now, you say, both of you in your statement, that the Jehovah's Witnesses teach that child sexual abuse is an abhorrent sin. That's right, isn't it?
That's correct.
And it's that teaching of the Jehovah's Witnesses that you rely on as an important element of your strategy to make the organisation a child-safe organisation. Is that right?
That, and making sure that we conform with whatever legal requirements there are. We've taken the recommendations of the Royal Commission seriously.
Mr. Spinks, I said it's an important element. And what I'm saying is one of the things you say with regard to what you do to make your organisation child safe is that you teach Jehovah's Witnesses that child sexual abuse is an abhorrent sin. Is that right?
That's correct.
Yes. And of course, just what child sexual abuse is in the eyes and in the teaching of the organisation is therefore important. Do you accept that?
Yes.
And to the Royal Commission, child sexual abuse includes sexual or sexualised activity by an adult with anyone under the age of consent. Do you accept that?
Yes.
Now, I'd like to refer you to the letter to elders at tab 7 and seek your clarification with regard to something. In particular, if on page 2 you would look at paragraph 10, which is headed Congregation Considerations, and you'll see some distinctions are drawn, and in particular the sentence I want to ask you about is the last sentence, but by all means read the whole lot. And the last sentence says, rather, this is in relation to what is child sexual abuse, we are referring to an adult guilty of sexually abusing a minor who is a young child. I don't think there's any question about that. And it goes on, or an adult guilty of sexual involvement with a minor who is approaching adulthood but was not a willing participant. Now, the question there is really this. This seems to be saying that within the eyes of the organisation and teaching of the organisation, a minor consenting to sexual involvement with an adult, a more mature minor, or as it's put here, a minor who is approaching adulthood, is not regarded as child sexual abuse.
No, that's not correct. That's not the intent of that, and if I could briefly explain.
Yes, so what I'm getting at is to understand the organisation's teaching or understanding as to where the line is drawn with regard to looking at the question of age or majority, where the line is drawn with regard to what is child sexual abuse.
I think if you go back to earlier in the paragraph, if I could, to give that context, and remembering that this is in addition to whatever legal implication, this is a congregation consideration. It says, when discussing child sexual abuse from a congregation standpoint, we're not discussing a situation in which a minor who is a willing participant and who is approaching adulthood is involved in sexual activity with an adult who is a few years older than the minor. So while that's a broad expression, our experience has been, for example, where we have seen it as child sexual abuse. One of the reports that we provided to the Royal Commission, where we viewed it that way, the elders have reported it that way, but the authorities don't necessarily view it that way, where the age gap is close. So that's not to be interpreted to say if the minor is willing. There are situations where, for example, a 19-year-old and a 16-year-old may have a consensual relationship. Now, there may be an implication under law, there may not. The same with the congregation. Were these close ages and consensual, or was the age gap such that there's either a legal implication or a congregation implication?
So basically you're saying is that final sentence must be read as qualified by the first sentence. It's talking about two people relatively close in age.
Correct.
Right.
What is understood by a participant who is approaching adulthood? What does that mean?
For example, Your Honour, there may be a 16-year-old whose age of consent, and we're not, while we promote high moral standards, we're not so naive as to think that 16 and 18-year-olds aren't having sex. So we appreciate that there are circumstances where you've got two consenting people. One is technically by law an adult, one is approaching adulthood. So it's in that context.
Again, ask you, what do you understand to be someone approaching adulthood?
That was the example I used, Your Honour, where...
16-year-old?
Well, not necessarily.
Well, that's what I'm trying to find out.
Well, I think the law is probably clear to us on that. For example, a 16-year-old may be able to consent. And so again, if it was a 16 and an 18-year-old, we are not talking about here young teenagers with adults. We're talking about where there's a similar age.
I understand what you're talking about. I'm still trying to find out what you understand to be a participant approaching adulthood.
It would always be someone of a close age to 18, Your Honour. That's our understanding. You know, that's how we view it, taking into account the whatever legal implications there are too.
So it wouldn't include a 16-year-old in your understanding?
I did mention the example that the law would permit a 16-year-old in some states to have sex with an 18-year-old. We're not going to necessarily view it differently if they're of if it's a consensual relationship between a 16-year-old and an 18-year-old.
Well, let's test it further. What about a 15-year-old?
I think in most cases the law would have an implication there as well that we would take into account. And each situation we would get legal advice, but also make a determination: is this two young people of a similar age that have a consensual relationship, or is one using his, for example, authority or older age to take advantage of the younger person?
Well, the difficulty, Mr. Sphinx, that you face, isn't it, is that according to your teachings, the Bible doesn't specify an age as to when one reaches adulthood.
That's correct.
And I suppose in ancient times, and you'll correct me if I'm wrong, it may have been at the time that the scriptures were written that someone in modern times would be regarded as very young, like a 13, 14-year-old might be able to marry. Would that be right?
It's certainly not in the Bible. Thank you for... I appreciate that is the case in some cultures, but the Bible teaches very clearly that it would be someone who's past youth. But your point is taken that there's no strict rule in the scriptures.
Well, but that leaves us with the question of when is past youth?
I probably am not understanding your question. I don't want to be evasive because, again, we've had, and I'll be very happy to provide the details of this to the Commission, we've had situations recently because of our heightened sense of awareness of these issues where the elders have taken a young couple, one recently in Victoria where the girl was 15 and the young man was in his early 20s. They're from a culture outside Australia, courting young. We they were obligated under law to go to the police. The elders went with the family to interpret, and the police said in that instance that they didn't view it as a sexual assault of the minor. So there are complications. From a congregation point of view, we probably have a stricter view than the law.
Mr. Spinks, I don't want to spend time on it. The simple point is this, is the law, perhaps for reasons of pragmatism as much as anything else, and draws clear lines between when one can consent and when one can't consent legally to sexual intercourse, whereas the Jehovah's Witnesses don't. And would it not make your approach to things a lot easier and a lot clearer if you just followed the clear lines of the law in relation to this?
That's a complete misunderstanding. I apologise, Mr. Stewart. This is a secondary consideration to the law. Jehovah's Witnesses will always abide by the law. So this expression relates to where the law doesn't have an implication. The congregation may still view it as child sexual abuse or not, but it's always secondary to the law. So I can't see a situation where that would occur.